Can your contract prevent the client from giving you a bad review? Let's find out today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. Today we're going to be talking about no review clauses, kind of gag orders in service contracts that prevent the client from giving bad reviews. But before we do that, mosey on over to the YouTube channel over at Wedding Industry Law. Like and subscribe there, leave a comment, or like and subscribe wherever you get your podcasts from. I think we have maybe 3 reviews on Apple Podcasts. So if you are so inclined, please tell the world that you watch this or listen to this podcast occasionally, if at all. And you will join the likes of my mother, who also listens, all 3 or 4 of you. Anyway, great episode today, super short, talking about the no review clauses. Now, to kind of anchor the episode, I want everybody to understand that from a contract law perspective, meaning that the laws and statutes, proclamations, the regulations that govern your contract, the one that your client signs, there are typically going to be 2 levels to that. There's going to be a federal level, meaning that there are going to be some federal laws that govern that contract, but mostly there are going to be state laws that govern your contract. Does that make sense? So the federal government, the Congress, has the authority to tell you what to do in some capacity with your contract, but mostly that's going to fall to your local state government. When I say jurisdiction, that's typically what I'm talking about, is your state government has enacted legislation that concerns how and what can go into your service contract. So the issue today before us is, can your service contract, that is the contract that you give the client to sign at the outset of your relationship, can that contract have an obligation to the client that they will not give you a bad review regardless of what happens? We're calling that the no review clause. So the first thing we're going to do is we're going to talk about a specific federal law, and that is the Consumer Review Protection Act. So this is a federal law that applies to every state. And that law provides that no form contract that's used for services can prevent someone from giving a bad review. Now, there are a couple caveats with this. The first caveat is that the term form contract is a term of art and is defined in the statute. And form contract means that it's a contract that has standard terms and that the contract does not provide, or the service provider does not give the client a reasonable opportunity to negotiate the standardized terms. Okay, that's the form contract that is applicable to the federal law. So my understanding of this federal law is that most of you are going to fall into this because you provide a service to consumers in the public, but you might not apply to it because your contracts are not form contracts. So even though most of you have standardized language, you typically give the client the opportunity to negotiate those terms. In other words, you don't ever say it's take it or leave it. If you do say it's take it or leave it, then maybe you do fall under this federal regulation. And again, the federal regulation says you cannot do that. If it's a form contract, you cannot prevent the client from giving you a bad review in that contract. So I'm not going to tell you whether or not you have a form contract that means that you fall under this federal law. It's possible that you do. I don't have an answer to that. So if you have boilerplate contract, you do not allow the client to make any changes. It's take it or leave it. And you also have that no review clause, you might be running afoul of the law. If you are doing things other than that and you have a no review clause, then you might not be underneath the federal law. So let's put that federal law over to the side for a second. Because again, federal law applies to everybody, although based on what you do, that specific law might not apply to you. What about your state law? Now, there are a certain set of states that have state statutes, that have state laws that prevent you from doing that are broader than the federal law. California is an example of one of those. In California, the typical service contract cannot prevent a client from giving you a bad review. It's called the Yelp law in California. Some other jurisdictions have that. So setting aside the federal law that we just talked about, you could potentially be in a jurisdiction where it is illegal or it is improper or it is not allowed under the law, California being an example of that. So getting around that again, Rob, can I have a no review clause in my contract? It's going to depend on how you operate, which would dictate whether you fall under that federal statute. And then it's going to depend on whether or not you fall into a jurisdiction that also doesn't allow them. If you don't fall under the federal statute and you don't fall into a jurisdiction that doesn't allow them, then it's possible that you could have one. I would argue that it's probably not a good idea. And that I'm not saying that a trial judge, goes against the law, but sometimes they don't, if it doesn't feel good in their stomach, then they're going to rule against you. And I've seen that happen, unfortunately. So I can't guarantee you that even if you're outside of a jurisdiction, that it's still going to work for you. I can't guarantee that. And then from a moral standpoint, from a business standpoint, I can't speak to that because if I was an awesome business owner, I would have my own spaceship. So I would leave it to people, experts like Alan Berg, Brian Lawrence. I don't know who you listen to for your wedding business advice, but David Turturro, don't know. I would refer to them with regard to whether or not it's a good idea from a moral or business standpoint to have that in there. I don't. If I ever see one of those, I run away. Personally, don't like them. So Rob, when can I tell the client not to give me a bad review? That's an excellent question. So as we've discussed, it's less likely to be allowed or enforceable the earlier you are in the relationship with the client. Let's say that you have already done the work or you're already doing work and maybe the client doesn't like what you did or there's a dispute. In other words, you want to both fire each other or cancel the agreement. I would refer to you the previous episodes where I talk about cancellation agreements and I talk about settlement agreements. At that point, it's perfectly fine to bargain for silence. It's perfectly fine to prevent the client from giving you a bad review when there's already been things done and there's a bona fide dispute. That is a settlement agreements with confidentiality and non-disparagement are signed 1,000 times a day. That's perfectly okay. So you can do it at that point in time. Whenever you've reached a point where you want to cancel the original contract or you are wanting to enter into some type of settlement with that client. This is after you've already established a relationship with that client. Now, you could theoretically have a client sign a non-disclosure agreement or literally a contract that stifles speech at the same time that you have a service contract. However, I'm not sure the effect that that's going to have on the service contract under the laws. And I'm pretty sure that no one's going to sign that. If someone comes in to buy flowers or to buy your time to photograph their wedding and you provide not only a service contract for them to sign, but also a non-disclosure agreement or some type of other form talking about no review on its own, I would run away. You're never going to be able to do that. And if you can do it, call me because you're an awesome salesman and I could use you on my team. But in other words, you could theoretically get the client to agree not to say anything, but it would have to essentially be its own agreement with its own consideration. So in other words, it would be something along the lines of you have a service contract over here, but then maybe you're giving the client $500. Maybe you're giving the client an extra photography session or an extra 3 hours, or you're giving them an extra hour of video production. Whatever the case is, you are giving them something in order for them to give up the right to review what you did. It's possible under the laws of the states that you could do it that way on its own, in its own contract. The closer you get to being in the service contract, the more likely it is, in my opinion, that you're going to run afoul of those statutes if you're in one of those jurisdictions. Although, who knows? If you explicitly lay out that there's consideration for a part, again, if there's consideration, money exchanging hands, something of value exchanging hands, other than the service contract, for them not to disparage you or give you a bad review, it's more likely to be upheld, but I can't guarantee that. So that's going to be the two situations in which you could bargain for silence. One, later on in the relationship, signing a cancellation agreement or settlement agreement, or an altogether separate agreement that specifies what is being exchanged for the promise not to disparage you or give you a bad review. I hope that makes sense. It can kind of get muddy with this kind of stuff, but at the end of the day, man, like, I'm not a huge fan of those things. And if you need that in your contract, I would highly advise that you listen to business podcasts in the wedding industry and understand that might be a failing of your operations. I'm not here to judge, but all I know from my own experience is that if I see those, it's an immediate red flag for me. So can you do it? Again, depends on federal law, depends on state law, where you sit, how you operate, and how far along you are in the relationship. And I think that's going to do it for this episode. Super quick episode, where I'll call them super quick. So who knows? I don't know. You might have already stopped listening. Probably statistics are showing me that no one listens. So kudos to you if you've made it this far into the podcast. If you like what you're listening to, like and subscribe where you get it. Go over to YouTube, watch, subscribe there, hit the notification bell. I'll be your best friend. And with that, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.